Dear students, welcome back. In this video, we shall continue with the Companies Act of 1956. So, in the last video, we discussed about what is Companies Act of 1956, the important terminologies we come across there, and the difference between public and private company, then MOA and AOA, its difference. Now, today we shall discuss about the importance of MOA. So, the importance of MOA is it defines the rights and liabilities of the members, and it shows the capital structure of the company, it shows the object of the company, and also it helps to specify the state in which the registered office of the company is situated, and it shows the constitution of the company, and also it specify the conditions under which the company has been incorporated. So this is like a general information to everyone, no, a new person, or if suppose if we want to go for any kind of an association, no, in the form of MOU, or some mergers, acquisitions, or joint venture where you try to expand your business or want to enter some international market like that. So it serves as some standards that the company is following in its functioning, so that we say, for example, like what is its turnover, or the its future plans, investments, and the capital amount, the share amount, the share price, like that, the basic details, and what type of company it is, what is the size of the company, all such specifications we can understand here. Now coming to the next very important aspect, that is AOA. AOA means it is Articles of Association. When compared with the MOA, it means here we it is like the rules and regulation, that is the bylaws of the company, according to which the director and other officers are required to perform their functions as regards and management of the company, its accounts and audit. So that is the rules regulations set internally to govern its functioning. So that is which is applicable to all the employees working within the organization, no. So what has to be followed, like that. So for each and every organization, no, it has it will be having its own articles of association. So in case of any violations, no, the company has all the rights to sue against the maybe the shareholders or the employees or to anyone concerned. So that we call as AOA, that is the importance of AOA. Here now let us understand what are the contents of AOA. The contents of AOA includes the rights of different classes of shareholder, then use of common seal of the company, that is when we have to use the seal and to what it is applicable, no. So that we will be discussing, and different classes of shares and their right, then appointment, then powers, duties, salary of MD, manager, and the secretary, that is different categorizations and classifications that we come across here, that we will be discussing, and borrowing power of directors, voting rights of members who can vote for different various purposes, that also will be discussing, and the board meetings, board members, the proceedings, and the last, that is winding up of company. So that we come across under AOA. And in order to introduce all this, periodically the companies will be that is claiming, or it will be sharing the details in form of the brochure or the diary, no. So that we call as, or annual the reports, that is called as prospectus. It is the basic document for raising funds from the public. So based on that, suppose the basic information when it is being shared to everyone, suppose if anyone is interested to transact with the company in terms of like by purchasing the shares, no. So that the information will be shared in the form of prospectus. So where it serves as the basic document for various the reasons. So that is, it means the document described or issued as prospectus and includes any notice, circular or advertisement inviting deposits or offers from the public for the subscription or purchasing of any shares in or debentures of the company. Thus, prospectus is a general invitation to the public to subscribe to the capital of the company on the conditions specified in the applicable form. So, this is an important the term or a question in the exam, what is a prospectus, and elaborate on its applications. And now let us understand what constitutes a prospectus. It is, as we know, it is an invitation to a public, an invitation be by or on behalf of the company. It must be to subscribe or to purchase, and it must relate to shares, debentures or any other instruments. So that we call as prospectus. And here we have certain statements in lieu of prospectus. So what are the certain conditions and statements that can be mentioned in the prospectus, so which helps the promoters to prepare a draft looking at the statements, and if the statement contains any misinformation or omission, the liability or civil and criminal is same as in the case of prospectus, that is a fine up to 10,000. Suppose in case if you don't mention any important conditions and you follow the same, a serious fine can be imposed. So that is the importance of prospectus. Here we have different types of prospectus, like self prospectus, then abridged prospectus, and the other types also are there. The important one are the shelf prospectus and abridged prospectus. Now let us understand what do you mean by a shelf prospectus. That is a concept introduced by the amendment of 2000 of Companies Act. It is issued by the financial institution or bank for one or more issues of securities. So in case if you want to introduce a new security, then it will be mentioned in the prospectus. A public financial institute or public sector banks or scheduled banks whose main objective is financing shall file a shelf prospectus, and it is not required to file prospectus afresh at every time. So this is called as shelf prospectus. Now coming to the second one, that is abridged prospectus. Means every application form to contain a prospectus, the central government has prescribed that there should be one abridged prospectus with every 2 applications form. So that is the information in abridged prospectus to be given under 9 heads. So has the general information, capital structure of the company, terms of the present issue, then particulars of the issue, company, management and project, financial performance for last 5 years, payments, refunds, particulars of companies under same management, management's perception of risk factors, like that. So that is every new application form to contain a prospectus, we have to bring in certain information in the prospectus. So that we call as abridged prospectus when we have different kinds of application forms. So this is about the important the terms that we come across in a company under Companies Act. Now the important the procedure under Companies Act is how to form a company. So here we have to follow certain procedure. So it is called as formation of a company. Means a payment of registration. First it attracts a payment of registration fee. Suppose if you want to form a company, So whether as a public company or private company, the already we know the mandatory the procedures for formation of that. So here it will be having certain payment as registration fee, followed by power of attorney to fulfill various legal and other formalities, and also statutory declaration should be made by either an advocate of Supreme Court or as a declaration, and then or maybe by the court or high court practicing chartered accountant. Certain mandatory declarations has to be made. So that is with respect to what type of company, what is the size of company, what is the basic the investment turnover, the policy, the stakeholders policies, then shareholders information, all that, and followed by a name to the company. And to promote such companies, again under the SEBI, under regulations of 1997, the term promoters means a person or persons who are in control of the company. So that means the stakeholders are considered as persons named in any offer in any manner where they offer certain document as promoters. So this is about formation of company. Now let us discuss about the last concept, that is winding up of companies. So once a company has been formed and in due course of time, suppose maybe due to certain conditions like the unavoidable conditions, or if you want to want to shift from one domain to the other, one sector to the other, or maybe at certain conditions like the international entry or joint venture acquisitions, mergers, so where you want to close the company. So for that also we have to follow certain policies, that is the procedure that we call as winding up of companies. Winding up of a company is defined as a process by which the life of a company is brought to an end and its property administered for the benefit of its members and creditors. In other words, that is the words of Professor Goer, he says that winding up of a company is the process whereby its life is ended and its property is administered for the benefit of its members and creditors. An administrator, who is called as a liquidator, is appointed and he takes the control of the company, and he collects its assets, pays its debts, and finally distributes any surplus among the members in accordance with their rights. This we call as winding up of company, means where we have to follow certain procedure before we wind up. So whereby its life will be ended, and finally you will be distributing the any surplus among the members. Suppose left with any amount as the profit, it has to be shared. Again, in case you want to form a new company, again the same procedure that which we have discussed here under the formation of a company has to be followed. So these two are the important questions that you have to concentrate. Usually these two are the definite questions in the exams or the test. So this is about the Companies Act of 1956, introduced in the year 1956, again amended, re-amended in 2000, and now we are following, and very recently also it is been amended in 2013. So which serves as the basic for all other acts. So in the next class we will be starting with the actual compliances as one by one. no. So that is as mentioned in the first class as the different legislations, no, that is